Thank you very much, Mr. Chairman, and thank you too to the organisers of this symposium. I'm delighted to be back in Seoul, and it's a double pleasure to be able to speak about something this afternoon in which I have a very strong interest. And I hope that some of the lessons that we can learn from the Hong Kong and Singapore experience have resonance in Korea, but we also, of course, have much to learn ourselves from you about how we manage and control corruption in Hong Kong and I'm sure in Singapore too. Now, my talk today is really about Hong Kong's anti-corruption legislation in comparative perspective. What I'll be doing, if I can find my way onto the next slide, what I'll be doing is focusing on the effectiveness of the legal provisions governing bribery and serious conflicts of interest in Hong Kong, and seeking to draw from that some of the lessons and concerns that we might consider to be more widely relevant. And in particular, I'll be looking at the European experience as well to see how legislation has been adapted in many European countries and has changed over time. Hong Kong has generally got a very good reputation in preventing bribery, although I must say that we're not so good at preventing money laundering and cross-border corruption. On the Corruption Perceptions Index, which Mr. Cannon mentioned, the Transparency Index, we rank 18th at the moment, and Korea ranks 43rd. This is a perceptions index which deals with how people view corruption in their countries. It doesn't tell you about the level of corruption. It just simply says, on the basis of surveys, this is what we think about corruption in our country. Has it got worse or has it got better on an annual basis? Now, more recently, there has been another bribery index that has been produced by Trace International, and this is more specific. It deals with bribery. And on this index, Hong Kong would rank 3rd in the world, which is a pretty good score, and Korea would rank 17th. So Korea, on this score, does rather better, and so does Hong Kong. I think it would be nice to congratulate both Hong Kong and Korea on this, but I do have slight reservations about doing so. I think Hong Kong is good at covering bribery, and Korea as well. But we must remember that this doesn't take into account some of the changing forms of corruption. We might be getting better at controlling bribery, and I think we probably are, but it's also true that the forms of bribery are changing. The forms of corruption are changing. And it may be that our legislation is actually out of date, that we don't keep up to date with what is actually happening in the real world of corruption. One of my arguments in this paper is really that legislation tends to be a lagging indicator, and that you have to build in methods of keeping up to date, of keeping up to speed with. If you just rely on one piece of legislation that's been there for a long period of time, you can fall behind quite easily. In addition, I think that when we look at legislation, we have to consider how it changes over time, and we have to consider how appropriate it is for the corruption of that particular period. Now, like Singapore, corruption was tolerated in colonial Hong Kong until the 1970s. In the Hong Kong case, it was because the British did not want to disturb what they regarded as Chinese customary practices. Then they also believed that the top of their civil service was in fact clean, that it wasn't corrupt. So they were willing to tolerate it up to that point. However, and legislation against bribery was there. There was legislation. It just wasn't very effective legislation. It was introduced following English practice, and one of the problems with it was that the wording of the offence was to corruptly accept, And if you have that kind of phrase, it does require proving in the courts that there is an intent to be corrupt. In other words, the courts have to look at what is the intent of the accused in terms of whether that person is corrupt or was acting corruptly or not. And so you get into the minds of the corrupt, and the courts have to say, yes, that person was actually acting or intending to act in a corrupt way. And that may be difficult to prove, and it did prove difficult to prove in the Hong Kong courts. So quite a lot of people were not prosecuted for corruption who undoubtedly were guilty. The other problem, which I think might have been shared with Singapore during colonial times, was that the investigation of corruption was in the hands of the police force, which itself was corrupt. So there was a problem here that the legislation was not terribly effective, and the investigation of corruption was not terribly effective either. Eventually, it became clear in Hong Kong that corruption in the police was actually syndicated. And by that I mean that it's not simply a question of one corrupt policeman taking a bribe. What it is a question of is actually having an almost parallel organization within the police force. If you have a police force, you expect that that police force will engage in fighting crime. You expect that that police force will have some kind of community relations in dealing with problems that people have in the society. What you don't expect it to do, and this is what the Hong Kong police force was doing, is actually extracting rent from small businesses, from taxi drivers, from minibus drivers, and requiring that they pay that rent as a form of corruption in order for them to continue in business, where the corruption is a complete undermining of the functions of the public service, and where the functions of the public service are being used in ways which are so corrupt and so distorting of the public interest that they, in fact, are acting in a totally immoral and malicious way. Now, in 1970, the government eventually decided to act on corruption, and I was struck from Mr. Cannon's presentation on the similarities here between Singapore and Hong Kong. What the Prevention of Bribery Ordinance had in common was an implication of a zero tolerance of corruption in both the public and the private sector. Secondly, a willingness to shift the burden of proof to the defendant, and this seems in some sense a violation of common law, because the person should be considered innocent until proven guilty. But in this case, there is a question that you have to convince the courts that you were not acting corruptly in some instances. And finally, the provision of powers of investigation, which were very strong and which critics were to claim infringed civil liberties in some cases. And this was eventually translated into the Independent Commission Against Corruption, which is still the principal investigator in Hong Kong of corrupt offences. The legislation also differed significantly from the past. The words "to corruptly accept" were removed, and the offence became instead "to accept an advantage," without reference to whether a public duty had been violated by commission or omission. Now, I think it's interesting here to reflect on what Mr. Cannon was saying on his presentation on Singapore about the flexibility of anti-corruption legislation. I think that's a very important principle. I think what is happening here is that the legislation is trying to be as flexible as possible to cover the multifarious ways in which corruption might occur. And so what we would have here is the expectation that if you can prove that someone accepted an advantage without lawful authority, then you have a case for prosecution and you have a case for conviction. Significantly, in the Hong Kong legislation, there is absolutely no mention of the word bribery. The offence is to accept an advantage. So we don't actually use the word bribery at all in the Prevention of Bribery Ordinance, except in the title and in some of the subheadings. But in the text, there's no mention of the word bribery. So the offence is simply defined, and this is how you would be prosecuted in Hong Kong if you committed such an offence. It has to be a public servant or an agent for private sector cases, any person who offers, solicits, or accepts an advantage, and the advantage is broadly defined, for the purpose relating to the capacity as a civil servant or in the private sector, and does so without lawful authority or reasonable excuse. Such a person commits an offence. Very simple and very flexible. There was also a novel provision in the legislation that assets beyond salary, assets beyond income, without a satisfactory explanation became an offence. One of the cases I'll talk about in a moment is that of Peter Godber, who was a corrupt senior policeman in the Hong Kong police force, and his subsequent saga and arrest resulted in the creation of the Independent Commission Against Corruption. But one of the ways in which they prosecuted Godber was on the basis that he did have so much in the bank that he couldn't possibly have accumulated that money in his capacity as a senior police officer. He had no excuse for how he had accumulated that sum of money, many millions of dollars at the time, and therefore he was sentenced eventually, I think, to 4 years in jail. So this is the Godber case. What happened in the case itself, which caused shockwaves in Hong Kong, was that this police officer escaped from... He was being investigated for corruption, and he realized he had to escape. So he went to the airport, used his police identity, got on a plane to Singapore, and then subsequently went to Britain. Now, this caused a public outrage in Hong Kong, a real public scandal, which eventually resulted in major changes to the way that Hong Kong looked at corruption. He was extradited eventually and then sentenced to 4 years in prison in Hong Kong. They had to change the legislation again, and this is a reinforcement of the point that I'm making about the need to keep legislation under review. This was an ordinance that had only been in effect for 3 years, but Godber's behavior had shown that there were weaknesses in the ordinance, and so a number of other different kinds of measures were taken. And as you can see on the slide, I won't read it all out, but there were a whole range of minor amendments made to the ordinance to try and improve it and to make it better in terms of the prosecution of corrupt persons. Now, the Independent Commission Against Corruption, the ICAC, was created after the Godber case. It was a direct result of the Godber case. And this has very strong powers of investigation of corruption. I'll go through these because I think they are quite important. The ICAC took the power to investigate corruption away from the police, and it now has the authority to investigate corruption. The police do, of course, investigate corruption on occasions in relation to other offences, but the ICAC is the principal agent for investigating corruption. It also has powers of arrest, and it has powers of detention. In the ICAC headquarters in Hong Kong, there are cells that people are put in when they are arrested, just as it would be if they were arrested by the police. It has powers to obtain information on bank accounts, on property, on tax returns, on a number of things that we would regard as being essentially private matters. The ICAC has the right to acquire that kind of information. And these powers have caused some concern among civil rights advocates and among lawyers who tend to claim that the dice are loaded against the defendant in prosecution cases in ICAC. In fact, about 80% of ICAC cases result in convictions. The process is really one in which the ICAC refers to the Attorney General's Department to see whether there is sufficient evidence before a prosecution is put forward. So there is some kind of vetting process before the case goes to conviction, sometimes very long. We have a case at the moment in Hong Kong of the former chief executive who is being considered for corruption offences. And that investigation has lasted 3 years. And it's still not certain whether the former chief executive will be prosecuted or not, although we're promised an outcome from that in the very near future. Now, I suppose that when we consider this, when we consider the amendments that have been introduced to the Prevention of Bribery Ordinance, it did have a very salutary effect on transforming Hong Kong from a corrupt society into one in which bribery is now comparatively rare. The next figure that I have on the board shows prosecutions for corrupt offences since the creation of the ICC in 1974. I'm afraid that it may not be too clear, so I should explain it a little bit. The first 2 or 3 years are really before 1997, so most of this chart relates to post-1997. What you can see is that there was a fairly sharp rise after 1997, which was the date Hong Kong went back to Chinese sovereignty, a fairly sharp rise in corruption after 1997 in Hong Kong, but then dropping away in recent times, which is an indication of the success of the Prevention of Bribery Ordinance. The drop at the end should be even sharper because a lot of these offences are election offences, and in the earlier period Hong Kong didn't have any elections, so it wasn't there weren't offences of that kind, and they've tended to rise in recent years, whereas corruption offences for bribery have tended to reduce. Now, in the late 1990s, just before the resumption of Chinese sovereignty over Hong Kong, bribery was no longer prevalent, but what we had instead were the beginnings of serious conflicts of interest in Hong Kong. And I think this is important because I think most developed countries or developing countries now have this problem with conflicts of interest and how you deal with them legally. I think that the Prevention of Bribery Ordinance in Hong Kong is probably inadequate by itself to deal with serious conflicts of interest in the public sector. And so we have had the development in Hong Kong of other kinds of legal remedies to try and address this critical problem of these conflicts of interest which relate to things like deferred advantages, giving advantages to relatives, long-term advantages, sweeteners from the private sector to public officials, post-public employment in companies which the public official had some relationship to, all those kinds of conflicts of interest, potential conflicts of interest. And what do you do about them legally? Now, I've argued elsewhere that this is a really critical issue for many jurisdictions around the world, and that conceptually we haven't really thought about this in as great detail as we should have done. Eventually, perhaps, we will have some kind of schema where we can deal with conflicts of interest in a more comprehensive way than we do at the moment. At the moment, I think most countries, when they look at conflicts of interest, are saying, well, we have a general kind of offence which will try and catch everybody. We'll have specific offences that relate particularly to the civil service. And then thirdly, a new development has been value-based integrity management, where the attempt is to improve the ethical standards of public servants and to do so by fairly rigorous training and much more supervision than existed in the past. In the Hong Kong case, the landmark case was the Hong Kong versus Shum Kwok Shur, where there was a serious conflict of interest. He was the government's chief property manager, and he gave contracts worth $150 million to companies controlled by relatives. What the courts decided to do, he was prosecuted under the offence of misconduct in public office, which is a common law offence, a very ancient common law offence, but which was expanded by the Hong Kong courts and by the Hong Kong Attorney General's Department a long way beyond what was being done in Britain. So the offence still exists in Britain, but the Hong Kong law is considerably advanced on what the British situation is. In another case, in Hong Kong versus Sin in 2005, the courts decided that the offence should now occur when a public official, in relation to his or her public office, willfully misconducts themselves and does so without reasonable excuse or justification, and where such misconduct was serious, not trivial. Now, I have to say that this misconduct in public office offence caused considerable concern among Hong Kong civil servants, because the offence is what I would call a blunderbuss offence. It tries to catch every civil servant who might be involved in a conflict of interest. And for that reason, it's probably not the best way by itself to legislate against this, although it has had a lot of success in Hong Kong, and but it needs to be more clearly specified in the ways in which it's going to be applied. Some of the issues are who is a public official. That is a very critical issue because it's not always clear who a public official is. Is a university professor a public official? We don't know. The courts have not yet decided. Is the manager of a public corporation a public official? We don't really know. But the legislation has been in effect, or not the legislation, the offence has been in fact refined by a recent case when the courts decided that it was not possible for minor officials to be guilty of this offence, and that the offence should be restricted to those who really did have public duties which were being violated. So it cannot be used in quite the same blunderbuss way, the same general way that it was used in the past. Now, I want to move on finally to a comparison with Hong Kong in international perspective, particularly European respects. And here I want to look at the nature of legislation, corruption prevention practices, and processes for reviewing and monitoring corruption prevention legislation. If you have a society which has strong anti-corruption values, such as the Scandinavian countries, you could probably get away with dealing with corruption under the penal code. And you may not have a specific act to deal with corruption in those countries, but instead rely on the trust and goodwill of the public. In most countries, however, they do have legislation against corruption, and in most countries, but not in Russia or Slovakia, corruption is defined as accepting an advantage, which may be material or immaterial for the commission or omission of the act relating to official duties. So it relates still to duties in that sense, but accepting an advantage has been generally accepted as the wording of how you prosecute corruption. In England, the Bribery Act of 2010 uses the form offers, promises, or gives a financial or other advantage, and the law using the phrase corruptly accepts has now been repealed. European countries, as I said, normally maintain the link between accepting an advantage and the performance of public duties. In the European anti-corruption legislation, there is some standardization of the approach to corruption, and I think this has great value in monitoring and reviewing legislation. The Council of Europe's Group of States Against Corruption, which is called GRECO, was formed in 1999. It has 47 member states, and what it does is to review how anti-corruption legislation is performing in various countries in Europe, and that is, I think, a useful reform measure. I have said already that I think that in countries where corruption is perceived to be at a low level, in the Scandinavian countries in particular, normally on the Transparency Corruption Perception Index, countries like Denmark, Finland, Sweden, Norway score very highly. And they score very highly because there seemed to be a kind of a relationship between the public and the government, which assumes that corruption is such a venal crime that it will be reported anyway, that the public will report it, that you don't need some kind of agency to do the investigation, because the public themselves will tell you that there are corrupt offences being committed. But in other European countries, in Eastern Europe in particular, the tendency has been to create anti-corruption commissions. I should say, with regret, that most of them seem to be failures. And it's interesting to speculate on why the Eastern European countries have had so many failures in putting these anti-corruption commissions into effect. I think it's because primarily they do not have the characteristics that an anti-corruption agency ideally should possess. I know that many anti-corruption agencies now are looking for principles on which they should base their work. But there are certain things that do come out of the Hong Kong and Singapore experiences which I think are important. First of all, independence. If you have an anti-corruption commission, it needs to be independent from government. Secondly, you have strong powers embodied in effective legislation. Thirdly, you have no competing agencies dealing with corruption issues. One of the problems in Eastern Europe is that there are many different agencies dealing with corruption. And because there are many different agencies dealing with corruption, there are inevitably turf wars between different agencies. A single agency is a better way to go. Fourthly, and this I think is neglected in too many places, the anti-corruption agency needs a presence in the community. If you're simply a centralized body and you're sitting in the capital, there's an awful lot of things going on you don't know about outside the capital. It should be that the agency should be a visible representation of a political and community will to stamp out corruption. And in some European countries, although the agency formally exists, none of these conditions have actually been met. Another difficulty, of course, is implementation. And although legislation can be well drafted, unless it's implemented properly, that depends very much on the attitudes of government and the public. I should also say that this business of policy transfer is not all that relevant in the Hong Kong case, where there is a democratic country involved. In attempts to apply the Hong Kong legislation elsewhere, there have been problems because many people in democratic countries say, why should our liberties be compromised in this kind of way? And so the Hong Kong experience has not been relevant in that sense. I mentioned GRECO earlier, and just to repeat what I was saying, it's important to monitor change, to keep up with change. GRECO does these periodic evaluations of countries, So it will go to a country like Germany and say, you're doing pretty well on your anti-corruption legislation and implementation, but you ought to do better on the disclosure of your parliamentarians. And it will take a theme like that, and it will go to different countries in Europe and say, well, what are you doing about disclosure of your assets of people in those countries? Now that seems to me to be a valuable kind of exercise to do occasionally, is to keep monitoring different areas of corruption practice, or potential corruption practice, that need legislative attention, or need at least some kind of attention from agencies which are concerned with anti-corruption matters. I think that this periodic review idea is a very good idea coming out of Greco in the European context. So here are my conclusions. There are 4 of them. Effective anti-corruption legislation is a necessary but not a sufficient condition for corruption prevention. You need good laws, but you also need something else. You need the support of the public, and you may need this kind of sensitivity to changing conditions in corruption in any place. Secondly, reform mechanisms are needed to adapt legislation to changing patterns of corruption. If you think you've passed a piece of legislation and do nothing about it, then it's not going to be as effective in 5 years' time as it is perhaps today. Implementation is a major problem. Independent anti-corruption agencies can be very effective in solving that problem if the right conditions are in place. But again, there has to be, as Mr. Cannon was pointing out, the political will to put that kind of investigatory mechanism in place. Finally, and this is a theme that I really feel quite strongly about, and that is not sufficient attention is paid in anti-corruption activities to the public. The Hong Kong experience suggests that what was really quite critical was winning the public on board. The Hong Kong ICAC has a community relations department that goes down to the grassroots level. And it went out and it knocked on doors and said, listen, we're in business, we're against corruption, this is what you can do, this is what you can't do. And this is what the legislation says will happen if you violate the law. There's also a positive side to it. People themselves begin to develop values that will not permit and tolerate corruption in their society, because they realize that it will be detrimental to so many aspects of their lives. I know when the ICAC went knocking on doors in the 1970s, it would try to address what concerned people in their own ways of life. So if they were in a housing estate, they would knock on the door, a housewife would come to the door, and they would say things like, do you want your daughter to grow up in an atmosphere of vice? For a taxi driver, they would say, how much of your profits are going away in corruption? They would appeal, in other words, to the self-interest of the society. Now, if nobody does that, then the difficulty is that all kinds of misconceptions can arise about the nature of corruption. And in the Hong Kong case, we know that to be the case because we did surveys, the ICAC did surveys, academics did surveys, and we found that perceptions of corruption were very different between the public and the ICAC. But where there's a public education program where these kinds of values can be pursued, then there's a real chance that you can change some values in the society along the lines that you want to go, along the lines that your culture thinks is the way that things should be done, and should be done in an ethical and a way that is not corrupt. Thank you very much.